Welcome to Constitutional Chisme.
A law baddie's guide to the legal basics.
I'm your host, Stephanie.
And I'm your co-host, Harleigh. Every week, we will drop an episode that you'll likely cover in your first year in law school or some other bar course in your law school journey. Make sure you pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week. See if you can guess which one.
This episode is sponsored by Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. We also want to go ahead and thank Kaplan Bar Prep for partnering with us. If you or someone you know is planning to use Kaplan Bar Prep, be sure to have them use our code PASSWITHPONZ, PASSWITHPONZ, to save an additional $100 off your bar prep course. Make sure that you use the code so that we can continue to give out free bar prep each bar exam cycle. We also have a new and fun and exciting sponsorship, which is UWorld. UWorld has given us a discount code for everyone, which is Ponzanelli, my last name, the name of this podcast, at least half of it. PONZANELI and the number 10, 10, Ponzanelli 10. So you can save 10% off your UWorld bar prep. That one is more so just multiple choice, so MBE questions.
Yes. So like, for instance, the bar prep course that I used for when I was studying for the bar came with a UWorld subscription. And let me just say that the multiple choice on UWorld is elite because it reuses bar prep questions from previous years.
Mm-hmm.
And I don't know, the way that UWorld explains things just clicks in my brain. It's very, very conducive if you're a person who likes to do the wrong answer notebooks. It's very conducive to that.
Also, be sure to check out our link tree in the show notes. It is the website link, literally in the show notes. You can click that, and that's where you can find us on TikTok and Instagram. You can access our Amazon storefront featuring our favorite law school and bar prep essentials. You can join our Patreon community, and you can also find ways to send me a gift from my Amazon wish list.
Which I know you're all just chomping at the bit to find a way to send Stephanie a gift.
I still don't have that rug that I really want. So,
oh my God, everybody's just sitting around listening to this podcast like, God, I wish there was a way I could send Stephanie a gift. Here's your chance.
I know. Here's your chance. All right. You got to ask me what's going on today.
Yeah, we're shaking it up a little bit today, and we don't even have to because your girl is officially done moving. The audio quality on my end might be a little bit better this go around because I'm finally back with my OG setup. But yeah, we're shaking it up anyway. And Stephanie's going to tell us about a case. So what do you got?
Okay, so I'm really excited to tell you about this case because I actually met with someone on the podcast. Her name is Sophia. And she met who this case is about in one of her crim law classes.
Are you serious?
Yeah.
That's so cool.
Yeah, unfortunately, Harleigh and I did not have a good crim law class, so we don't really have a lot of cases that we personally read. Besides, I think maybe one on arson.
Girl, like 6 on arson. Before we get into today's case, I would like to go ahead and give a trigger warning for domestic violence. If that is a topic that is sensitive to you, this may not be the episode for you, so you can go and check out a different one. Or just be prepared for that type of content to be discussed in today's case.
All right, perfect. Thank you. So this case is called Crawford versus Alley. And I do want to let everyone know that this was decided in 2021, which I think is extremely important. Yeah. Especially with what I'm about to tell you. It's wild. Okay, so let's get started. On November 3rd, 2019, petitioner Shamika Crawford, from here on out will be known as Crawford, was arrested and charged with assault in the 3rd degree, petty larceny, criminal obstruction of breathing, and harassment in the 2nd degree. The complaint was...
Did you say criminal obstruction of breathing?
Yeah.
Like to take breath?
Yeah.
Okay.
And it's literally from the, what is it? This is a decision in order from the the judge.
It's so interesting to me how different states categorize different crimes.
Oh, yeah. This is in New York, by the way.
Okay.
I
Sorry, go
should
ahead. I was just making
led
sure
with
that I heard you right, because that was a crazy way to say that. Continue.
So, the complaint was by Myers, who complained that Crawford, a brother of hers, and an unidentified man kicked his face and took his gold chain. The police were called and Crawford was arrested. So, Crawford and Myers have 2 children in common. Myers lived with Crawford in her New York apartment along with their 2 children and a brother of Crawford. Crawford was then arrested and arraigned on November 3rd, 2019, and she was released on her own recognizance under the terms of a full temporary order of protection. Okay, so I'm going to explain to you guys what a full temporary order of protection is before we dive in a little deeper, okay? Okay, so a temporary order of protection, which is short, they usually use TOP, also known as stay away order, is a condition of release imposed on a person charged with, but not convicted of, a crime. It requires the defendant to stay away from the person named in the order while the case is pending, or face criminal contempt charges. These are not the same as civil orders of protection, which can be obtained by petitioning a family court. As the New York Times has explained, a criminal TOP is a well-intended pretrial precaution. However, it has been issued with such abandon in the city courts that it has become a sentence unto itself. Prosecutors in domestic violence cases almost always request the orders, and judges grant them almost reflexively. These orders are imposed just after arrest and frequently render defendants homeless and separate them from their family. This occurs even where the protected party does not want the TOP in place. So I wanted to let you know what that was before we got into it. So this happens and he requests a temporary order of protection, right? And she received the full temporary order of protection. So she's not allowed to go home. Okay. So
Because he was the victim, she's not allowed to be around him. He's the victim, she's the aggressor.
In this case, yeah.
Yes, okay.
But I will say, you don't get the full story. You just kind of like, this is all we know from this order right now. And that'll be important later.
That's how it tends to go in criminal cases, and especially once you get into like domestic situations.
Yeah. The full TOP required Crawford not to return to her apartment where Myers was staying and where the alleged attack took place. Mind you, I said earlier, this was her apartment, right? He lived with her.
So she, like, it's her name and it's in her name and she just straight up can't go home.
Yeah.
Now, granted, I will say, with the understanding right now that she's the aggressor.
Yeah.
Sorry, but it sounds like there's going to be a little bit more to it than that.
Yeah. So the people indicated that since the charges were violent offenses, the people asked for a full TOP. Crawford's argument for a limited TOP that would permit her to return home was adjourned to 5 days later, November 8th, 2019. So I'm going to explain what a limited TOP is, okay? So a full TOP means that the defendant must stay away from the home, school, and place of business of the protected party and have no contact with that person whatsoever, right? No matter what the circumstances, contact initiated or reciprocated by the defendant could lead to further criminal charges. A judge can also order a limited TOP, which allows the defendant to have contact with the protected party, but orders them to refrain from harassing, intimidating, or threatening that person. But the court granted full TOP. So she can't go home. She can't go near the kids' school. She can't go anywhere near any of them, right? So on the return date of November 8th, where Judge Alley presided, the people asked for continuation of a full TOP because the defendant attacked Myers in a home that Crawford and Myers shared, and there were about 17 prior domestic incident reports.
Oh, my God.
Yeah. Crawford's attorney asked for a due process hearing based on Crawford's property and family interests. I want you to take note. This case is called Crawford v. Alley. Okay?
Yeah, I was wondering why it's not State versus Crawford or Crawford versus State, which is what you typically see in criminal cases or their subsequent appeals.
Yeah, instead, this is versus the judge that presided in 2019.
Oh, so this is Judge Alley.
Yeah.
Oh.
Yeah. That's why I'm like, this is a crazy case. So Crawford's attorney asked for due process hearing based on Crawford's property and family interests, and Judge Alley responded that this is a hearing and that unless Crawford has some other argument, that the parties will remain safe with a limited order. The TOP will remain full. Judge Alley set and agreed to schedule for a motion seeking modification of the full TOP. The case was adjourned December 20th, 2019. Let me see. On December 20th of 2019 return date, Crawford's order to show cause was fully submitted. Judge Alley denied the application to modify the full order of protection on the grounds that there were no change of circumstances, there was nothing new in the movement, the papers on its merit. I don't believe it warrants the limited order or modification of the order. Weird, right?
That's her house. She lives there. And again, I can kind of see the purpose with the fact that, again, it looks like she's the aggressor. But I wish, and maybe you will get into this, I kind of want more information on what those other 17 domestic incidents looked like.
Yeah. So on January 30th, 2020, the parties appeared before Judge Stone. The order of protection expired January 30th of 2020, and the people made an application to extend the TOP. So, like, when did this start, Harleigh? That she couldn't even go near her home? In November, right? Now we're in we're in the next year. We're in January.
Oh my God.
Yeah. The order of protection
there.
Yeah. So she can't see her kids. She can't go home. She can't see the man. She can't go near his work. Nothing. She is quite literally homeless, right? So the order of protection expired on January 30th of 2020, and the people made an application to extend the TOP. Judge Stone indicated that it was not her practice to conduct a hearing on extensions or modifications of a TOP, but certainly will allow everyone to have an opportunity to be heard. Judge Stone reviewed photographs of the injured complaint. Judge Stone also observed that a significant amount of time had passed with no particular reason to believe this defendant is not following the order of protection. Judge Stone reviewed the domestic incident reports that were included in this Article 78 proceeding, of which Judge Stone stated, I don't believe they were presented last time it was before Judge Alley. Defendant's attorney informed Judge Stone that the ADA argued before Judge Alley that there should be a full order of protection on grounds of there being prior domestic incident reports between Crawford and Myers, without indicating that all of the domestic incident reports were made by Crawford against Myers.
See, that's what I'm saying, because it's a little strange that she would just go straight to what I assume is basically strangling this man.
Yeah.
Unprompted. What do those other 17 look like? Has she been the victim, or has she been escalating? Because that's an important distinction.
Yeah.
And who should be getting protection from whom?
Yeah. Crawford's attorney indicated that he did not have the domestic incident reports before Judge Alley. And Judge Stone observed that there were no argument that the defendant threatened Myers or had any issues with drug or alcohol abuse or any access to weapons. In contrast, Judge Stone observed that Myers had threatened Crawford and that he had an alcohol intoxication issue.
Oh my God.
Yeah, so
how did that not come? How do you not look at that? I'm sorry.
Right?
Let me not. I don't know you. Judge Alley, I don't know you. I don't know your life. I don't know how we missed that. Stuff happens. But this is somebody's life you're playing with.
Yeah, this is someone you made homeless for months. So
who was a victim. Now, don't get me wrong. She also was the aggressor, obviously, in this instance. But like,
after 17 times, like, dang.
Yeah, but there is a long history of her being a victim. And now you've made her homeless.
Yeah. Okay. I do want to go back a little bit because I think this part is important. So let me bring this up. Back in November, during argument, petitioner's counsel stated that the address listed on the TOP was petitioner's apartment and that she was the lessee of the residence and that she resided there with her young children for whom she was the primary caregiver. Counsel argued that barring her from the residence would result in barring the children as well. And the people stated that there was no indication in the file that a limited TOP was necessary or appropriate. And the court declined the issue, a limited TOP, without the people's consent, but stated that it would adjourn the case for an earlier date for that issue to be investigated. So can you explain to the listeners what just happened there?
Okay. So essentially what happened is her lawyer made the argument, like you said, she's the one who lives here. She's the one that takes care of the children primarily.
Mm-hmm.
And that as long as she can't go to the apartment, neither can the kids. So her and the children are now essentially homeless.
Mm-hmm.
And then the prosecutor turned around and said, but a limited TOP is not really necessary or appropriate. And there's nothing in our files that say that it would be. And because the prosecutor didn't want a limited TOP, the judge said, well, without the people's consent, which essentially means without the state's backing this up, without the state's prosecutor backing this up, we're just going to adjourn the case for an earlier date, and we'll come back and talk about it some more.
So they're like, you're cooked.
They're basically like, well, the prosecutor doesn't agree, and we're not going to limit a TOP without the prosecutor's say so. So you got to go and come back in 5 days because this is all happening. She was arrested on the 3rd and then she came back on November 8th. So her lawyer tried to make the argument of like, she literally owns that place. You can't keep her out of her own home. And the judge said, technically the prosecutor said, I literally don't care. And the judge said, me either, girl.
Yeah. So the case was adjourned to March 5th, 2020. On that day, upon the application of the people, the case was dismissed. Based upon that dismissal, Supreme Court dismissed the petition for a writ of mandamus as moot. Harleigh, can you tell us what a writ of mandamus as moot is?
Yeah, so writ of mandamus is literally Latin for we command. It's a court order that basically tells a government official or a lower court that they have to do something. It becomes like a mandatory thing that they have to do. So essentially, they requested a writ of mandamus saying, look at this case again. Tell them that they have to look at this case again. But once the case was dismissed, it was considered moot. And once it's moot, it essentially means there's no point in us making a decision on it. The issue is over. So now that the case is dropped, we don't need to tell them to do anything because the temporary order of protection also goes away.
Okay, perfect. So they found that the criminal court's initial failure to hold an evidentiary hearing in accordance with the petitioner's due process rights after being informed that the petitioner might suffer the deprivation of a significant liberty or property interests upon issuance of the TOP falls within the exception to the mootness doctrine, which has 3 different elements. The first one is a likelihood of repetition either between the parties or among other members of the public. 2, it involves a phenomenon typically evading review. And 3, there is a showing of significant or important question not previously passed on, substantial and novel issues. Although the issue is not likely to reoccur with respect to the petitioner, the parties are in agreement that the issue is likely to reoccur among other members of the public, as was stated by the criminal court judge who ultimately issued the limited TOP. It is the Bronx criminal court's practice not to conduct a hearing when a defendant challenges the prosecution's application for a TOP. So this was standard practice, right? To not really question it and just kind of grant it, which is problematic in itself. So the district attorney's office conceded that temporary orders of protection are regularly issued in domestic abuse cases in the Bronx, and Supreme Court in its decision stated that similar circumstances may arise in another proceeding by someone else in the general public. The correct standard is whether the issue typically, not necessarily, evades review. As to the second prong, pretrial temporary orders of protection typically last for only a short duration between court appearances, often for 1 or 2 months. This short duration between appearances results in little or no opportunity to litigate a challenge to any one such order while it is still in effect. Thus, the temporary nature of the short-term orders of protection serve in many ways to insulate them from legal challenge. So that's the problem, right? Like, you're like, it's so short that you don't really have time to argue them, which
Yeah,
1 to 2 months
this
of
is
being homeless is crazy.
yeah, and
Uh-huh.
this is a similar issue when we talk about ripeness versus mootness. So ripeness is, has it become an issue yet? And mootness is essentially, is it still an issue?
Yeah. So the impact of being barred from one's home, even temporarily, can be far reaching. Notably, petitioner faces the potential loss of specialized public housing, depriving a person of her valuable property right in a lease or tenancy interest by issuing a criminal court order of protection triggers the due process requirement. Moreover, in addition to the potential loss of her apartment, petitioner was barred from access to her children for nearly 3 months.
That's crazy. As the mother who was the primary caregiver, that's crazy.
Yes. And who that was her apartment, you know? So
Yeah, like, this is a property issue first, and then, like,
yes.
I say first, not to say, like, it's the most important, but, like, first and foremost, look at the fact that that's her property that she's being barred from. And then
Yeah.
2, considering the fact that she was the primary caregiver of these children, that now she's no longer allowed to see, point blank, period.
Her
That's
children, yeah.
crazy.
And they're stuck with the man who's a known alcoholic and aggressive.
Yeah,
So,
with 17
mhm.
prior incidents.
Yeah.
Yeah,
So
that's hard.
these present circumstances were similar to another case, which was the matter of FW, where a father appealed on due process grounds the Bronx Family Court's delay in holding an evidentiary hearing regarding the removal of his children from his care based on alleged parental neglect. And before the appeal was decided, the father prevailed at the evidentiary hearing, and the family court completed the neglect proceeding in its entirety, mooting the appeal. This court found that the mootness exception applied and reached the merits of the appeal. We held that the family court's delay in holding an expedited evidentiary hearing interfered with the father's fundamental liberty interests in the care, custody, and control of his children and violated due process in protecting the interests. So this case is brought up to show how this is a problem, right? Like they need to have due process.
This is also kind of what my research was about in family law, not family law,
Uh-huh.
reproductive rights.
Oh,
Reproductive rights in
cool.
the law was due process interest in the due process rights that you have when it comes to your children and whether or not you should be entitled to an attorney. Spoiler
Yeah.
alert, you're not entitled to an attorney the way that you are in a criminal case. You're entitled to due
Well,
process, but you're not entitled to an attorney.
girl.
Girl.
In sum, while this proceeding is moot as to the petitioner, it falls within the exception to the mootness doctrine because it implicates substantial issues that will likely reoccur elsewhere and that typically evade review, and we hold that the criminal court should have held a hearing. In order to issue a TOP and thereby deprive a defendant of significant liberty and property interests, there must be an articulated reasonable basis for its issuance while consideration of whether the defendant poses a danger, intimidation, or injury to the complainant. In one factor, there are other factors that should be considered as well. The criminal procedure law enumerates a non-exhaustive list of factors that a court shall consider when determining whether to order the defendant in a family offense case to stay away from the home, school, business, or place of employment of the family or household member or of any designated witnesses. Under the statute, the court must consider whether the temporary order of protection is likely to achieve its purpose in the absence of such a condition. Conduct subject to prior orders of protection, prior incidents of abuse, past or present injury, threats, drugs or alcohol abuse, and access to weapons. Indeed, in the instant case in January 2020 proceeding, after being appraised of all of the relevant information, including filing of 17 prior DIRs that alleged domestic violence against the petitioner by mayors, The criminal court articulated a reasoned basis for issuing in limited part.
So it's essentially, you can't just tell people they're not allowed to go home without something to back that up. You're going to have some form of hearing, or you're trampling on people's due process rights. You have to have something to back up going all the way to a full TOP, or temporary order of protection. You can't just do that. And in fact, in this case, it was extra egregious because they actually had evidence that they should have done a limited one instead. Not only did they not have evidence to back up a full TOP, they had evidence that should have been limited. That's crazy. That's awful.
Yeah.
That's awful.
So I'm going to tell you a little bit about how this case changed the way TOPs are handled now in criminal court. So on June 24th of 2021, the First Department handed down a decision in the matter of Crawford v. Alley, ruling that if a TOP interferes with a defendant's personal or property interests, such as rendering them homeless or separate them from their children, the criminal court must conduct a prompt evidentiary hearing in a manner that enables the judge to ascertain the facts necessary to decide whether or not the TOP should be issued. These hearings offer the judge an opportunity to examine the facts more closely than they could at an arraignment and decide if the order should remain in place, be limited, or removed. And I do want to add that her case was subsequently dismissed for lack of evidence against her. So your girl got in trouble and they were like, oh, oopsie, we didn't really have any anything to prove you did that. Oops.
Sorry, we didn't mean to do that.
Yeah, sorry you lived in your car for 3 months and didn't see your kids. You know, you won't get that time back. Yeah. So again, for decades, judges routinely issued stay-away orders of the TOPs at arraignments with little more than a prosecutor's request and the charges listed in the criminal complaint. The Crawford decision changed this practice by establishing that when an order of protection threatens to cause immediate and significant deprivation of a substantial personal or property interest, you have to have a constitutional right to a prompt evidentiary hearing. This is your due process protection. The appellate court recognized that being ordered to stay away from one's home can be devastating, affecting not just housing, but also the ability to care for children, access work material, and maintain basic stability during an already difficult time. It's now called a Crawford hearing, and a Crawford hearing isn't a favor from the court. It's a legal right when facing the loss of your home. Whether you're the lease owner, you pay the rent, it's your property, it is your right for the judge to review the case before deciding whether or not you have to stay away.
Wow. So is a Crawford hearing something that is only happening within New York? This was a New York appellate case, right? Yeah, New York state courts. It's a legal proceeding in New York state courts where a defense attorney challenges a full stay-away temporary order of protection.
Okay, so I wonder if we don't have that in Arkansas.
No, but I also don't think that Arkansas's are so... Yeah, you have to prove that someone is a credible threat before you can get in Arkansas. In Arkansas, it has to be a finding that respondent presents a credible threat to the physical safety of a person named in the order of protection as a family or household member, a child of the family or household member, or a child of the respondent or enjoined party, or an explicit prohibition against the use, attempted use, or threatened use of physical force against the person named in the order of protection. So you have to show that the person is a threat before an order of protection can even be issued in Arkansas. Whereas it sounds like in New York, it was something that happened automatically if you had been accused. Because I actually sat in on several order of protection hearings when I was externing with Judge Taylor.
Oh, okay, cool. So what were those like?
They were really hard to watch. I won't lie.
I think what's a little bit hard about this case is like, in those situations where it is like an emergency, you know, like you might want to be able to be protected. And I'm thinking of like, she was the woman who owned the home, and that's not always the case, you know? So I'm just like, it's a little stressful if he had owned it, you know?
Yeah.
And she still is homeless. So I think there's a lot. I think it's really hard, you know?
Yeah, that's what makes anything to do with domestic disputes particularly difficult, because there's often kids involved.
Yeah.
There's a lot of things to consider.
Mm-hmm.
What truly is safest for all the parties involved?
Mm-hmm.
It's really, really hard, because it's already there's no other word to say, but it's just a really shitty situation all around.
Yeah. Yeah. I think it is crazy that this didn't happen until 2021.
That is
Uh,
crazy to me. That
yeah.
it took this long for like a particular set of circumstances. And I'm sure she's not the first
Mm-mm.
to have
No.
been done dirty like this.
Yeah. So like, I think it's really cool that she's going to law schools and talking about her experience.
Yeah.
That would just be, I don't know, I probably would be crying during that, because she
Yeah,
told me that. Yeah.
that's really, really, uh, that's really brave and really strong. I don't know if I would be able to like tell the story of how I was in what sounds like an absolutely terrifying situation, and then
Yeah.
somehow it all gets turned around that I end up homeless and not able to see my children for 3 months.
Yeah, she mentioned that the lady said, like, all she had was the clothes she had on. She couldn't get anything.
God.
Yeah. So she was literally homeless. Can't see her kids, and what she had on was the only thing she had. And so, I mean, like, I don't know, I just can't imagine, going through that. And so, yeah. But yeah, if anyone wants to hear a little bit more about that part, I do believe it's in Sophia's episode. Um, that wasn't that long ago. So you can kind of hear from her perspective of what it was like to have her there. And that's what interested me in the case for us to have it.
Well, that was a really interesting case.
Yeah.
It was a really
Yeah.
sad
Very sad.
case, but it was really, really interesting.
Yeah. And I think it brings good awareness.
I agree.
Um, all right. Well, that's it for today's episode.
Such a sad case.
I know, I'm like, I don't know what to do, but besides close it up.
Yeah, that's all you really can do. Well,
Yeah.
I think you did a great job breaking it down. And yeah, go listen to that episode and hear what Sophia has to say about it. And I don't know, maybe tune in next week, see what we got going on. Well, thank you for doing that case, Stephanie. And thank you again to our sponsors for today's episode, Valmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. And a big thank you to Kaplan and UWorld. Don't forget to use code PASSWITHPONZ for $100 off your Kaplan bar prep. And you can also use Ponzanelli 10 for 10% off of a subscription to UWorld. Again, you can check out the link tree in the show notes. That's where you're going to find links to follow us on TikTok, Instagram, access our Amazon storefront, and join our Patreon community.
And buy me a present.
And maybe buy Stephanie a present if you're feeling so inclined. Maybe buy me one too. Maybe I'll start begging. Spare change. Spare change.
It sounds creepy.
Have you not? If you know that audio, let me know. I know the audio. Do you know the
I know,
audio?
but I just don't like it.
Spare change. Spare
Pick a different audio.
change. Okay. Well, anyway, bye.
Bye.